Hello, everyone. I am Damon Moore. I'm an attorney and I am your presenter, and I'm excited to bring you this presentation about the basics of Indiana divorce law. We're going to cover 4 topics in this presentation: divorce, child custody and visitation, child support, and property division. At the end of the presentation, I'm going to give you a free gift that is sure to help you work through this challenging period of time in your life. If you have any questions, then you're welcome to reach out to me. Let's get started. If you want to know the grounds for divorce in Indiana and what they are, then listen closely. In Indiana, there are 4 grounds for divorce, or to say it differently, there are 4 reasons that a judge will grant a request for divorce: irretrievable breakdown of the marriage, conviction of by either of the parties subsequent to the marriage of a felony, impotence existing at the time of the marriage, incurable insanity of either party for a period of at least 2 years. The first method on the list, irretrievable breakdown of the marriage, is the most common. This is commonly referred to as a no-fault ground for divorce. The idea here is that one of the parties to the marriage says that the marriage is broken down and they no longer want to be married. Sometimes it's hard to accept when the other person doesn't want a divorce, but the fact of the matter is that the judge will grant the divorce if one of the parties says he or she wants the divorce. A judge in one case said it this way: one spouse is entitled to a dissolution of marriage even if the other spouse opposes it, assuming the procedural and jurisdictional requirements are met. Another court who dealt with this issue of no-fault divorce in Indiana ruled that Indiana's no-fault divorce statutes do not provide factoring in any pre- or post-petition conduct of either party. Claiming an irretrievable breakdown of the marriage is the easiest way to get a divorce because you only have to prove that one of you no longer wants to be married. The other methods that I'll discuss require you to prove something about the other spouse. The other methods require you to prove that the other spouse was at fault. Now, you may be wondering why someone would want to obtain a divorce on a for-fault or on a fault-based reason if he or she can get a divorce more easily with a no-fault reason. Well, although the general rule is that fault is not relevant to the dissolution proceedings except as related to the disposition or dissipation of marital assets, sometimes a person will use a fault-based reason to obtain a larger share of the property division. We'll talk about that later. For now, let's just take a look at some other fault-based methods of getting a divorce. Let's start with the conviction of a felony. The judge may grant a divorce if after the date of the marriage, either party has been convicted of a felony. The court may grant a divorce in favor of one spouse if there is impotence at the time of the marriage. And finally, the court may grant a divorce in favor of one spouse for incurable insanity of either party for a period of at least 2 years. Let's talk about child custody. If the parties have a child or children together at the time of the divorce, then the judge will address issues of child custody and visitation, child support, spousal maintenance, and property division. If the parties can agree on these issues, then the terms of the agreement can be incorporated into the decree. If the parties cannot agree, then this is how the judge will decide. Let's start with custody. There are 2 different types of custody under Indiana law: physical custody and legal custody. Physical custody is where the child lives most of the time. In most cases, one parent has physical custody and the other parent has visitation or parenting time. In some cases, parents do have joint physical custody, which means that the child spends an equal amount of time with each parent. That could be an alternating days or alternating week schedule, but there's equal possession. Legal custody, on the other hand, refers to the right of the parents to manage the affairs of the child and decisions of the child in education, medical care, and religious upbringing. Many parents share joint legal custody, but one parent often still has sole legal custody, sole physical custody. In Indiana, the court shall determine custody in accordance with the best interest of the child. In determining the child's best interest, there's not a presumption favoring either parent. The court shall consider relevant factors, including the following: the age and sex of the child, the wishes of the child's parents, the wishes of the child, with more consideration given to the child's wishes if the child is at least 14 years of age, the interaction and interrelationship of the child with the child's parents, the child's siblings, and any other person who may significantly affect the child's best interest, the child's adjustment to home, school, and community, the mental and physical health of all individuals involved, evidence of a pattern of domestic or family violence by either parent, evidence that the child has been cared for by a de facto custodian. Let's talk about the right to designate the child's residence. In a case that has children, the court will usually designate one of the parties as the one who determines where the child resides. The court may require that the child resides in a particular school district, a particular city, a particular county and/or surrounding counties, a particular state, a particular country, or there might not be any restriction. In my experience, this is one of the most heavily litigated aspects of a case. When thinking about the parent's right to collect child support, there are a few things to take into consideration. First, the starting point for the calculation of child support is something called the Indiana Child Support Guidelines. Lawyers and judges usually refer to this as either the guidelines or the child support guidelines. Second, child support may be ordered against either parent. Under Indiana law, the duty to support a child normally ceases when the child attains the age of 21 or is emancipated. In awarding child support, the court will consider the financial resources of the custodial parent and the standard of living of the child, or what the child would have enjoyed absent a divorce, the child's physical and mental conditions, and the financial resources of the non-custodial parents. Third, the guidelines provide a rebuttable presumption that the amount of the award which results from the application of the guidelines is the correct amount of child support to be awarded. Also, there are circumstances in which the court will depart from the child support guidelines, but you're going to have to give the court a reason to depart from the guidelines if that's what you want. To say it differently, if you want the court to give you more child support or require you to pay less child support, then you need to argue that the guideline support amount is unjust or inappropriate and that the judge should deviate from the guideline amount. Here's some examples of things that have caused the judge to order child support that was different from what the guidelines said that the support amount should be. One or both parties pay union dues as a condition of employment. A party provides support for an elderly parent. The non-custodial parent has extraordinary personal medical expenses. A parent is a member of the armed forces and the military provides housing. The parents share the controlled expenses of the child. The parent is on work release or a similar correctional program requiring the payment of fees. The children spend different numbers of overnight parenting time with the non-custodial parent. The custodial or non-custodial parent incurs significant travel expense in exercising parenting time. In one case, the court said, quote, "Evidence of a parent's net worth and assets are relevant subjects of inquiry in the proceeding to establish or modify child support." Let's talk about property division. In Indiana, the division of marital property requires a two-step process. The first step is to identify the property to include in the marital estate. The second step is to distribute that property in a way that is just and reasonable. Let's look at the first step first. The trial court must identify the property to include in the marital estate. The court in one case said, "This consists of both assets and liabilities and encompasses all marital property, whether acquired by a spouse before the marriage or during the marriage or procured by the parties jointly. This is important because a lot of people think that property that is owned by someone before the marriage is considered that person's separate property. In Indiana, the court does not presume that property acquired by someone before the marriage is that person's separate property. There are states where judges will make that presumption, but Indiana is not one of those states. In Indiana, the property is put in one pot and divided in a way that the judge believes is just and reasonable. In Indiana, the state statute says there's a presumption that the property should be equally divided, but a party can rebut that presumption by showing an equal division would not be just and reasonable. And the way you demonstrate that an equal division would not be just and reasonable is that you submit evidence that supports your belief that the property should be unequally divided. That evidence may include the contribution of each spouse to the acquisition of the property, regardless of whether the contribution was income producing, the extent to which the property was acquired by each spouse before the marriage or through inheritance or gift, the economic circumstances of each spouse at the time the disposition of the property is to become effective, including the desirability of awarding the family residence or the right to dwell in the family residence for such periods as the court considers just to the spouse having custody of any children. The conduct of the parties during the marriage as related to the disposition or dissipation of their property. The earnings or earning ability of the parties as related to a final division of property and a final determination of the property rights of the parties. There are cases that say that that list is non-exhaustive, by the way. So, if you have some other reason that you think property should be divided in an unequal way, then you should submit that evidence to the judge so the judge will consider that or those other reasons. Now, I told you at the beginning of this presentation that I would give you a helpful free gift. Here it is. I'm offering my very short ebook. It's called The Checklist, and I'm offering that to you for no charge. This is a short ebook that provides useful things that you should consider doing once you've determined that you're going to leave your relationship. You can send me an email and request that book, or you can check for a link in the description. I may have a link in the description for you to download the book. You can also check the description to schedule an appointment with me to ask any questions that you have.